been at the forefront in the legal community in Sri Lanka. For 40 years, he has led and he has held various positions, various important positions, and he's also the overall chairman of the disciplinary committee of the BASL. He has been in some of Sri Lanka's leading high-profile cases. Some of these cases that you have already studied, the Hotel Galaxy case, the Vijay Gunawardena case, just to name a few. And in more recent times, the Samita Samanmali case and Ms. Achala Priyadarshini's case. Now, in these cases, Mr. Arulpragasam has represented his clients, and he has won many cases for his clients, many high-profile cases. He is a brilliant product of law college and has been in many leadership positions even during his college days, ladies and gentlemen. And he has been part of this program over the years, helping to train batch after batch of apprentices, and they have benefited from his immense knowledge. And today's session too is going to be a very good session, so I hope you enjoy it, you take notes and benefit from this wonderful session that we are about to present to you. Thank you very much, sir, for joining us. Over to you, sir.
Thank you, Shayan, for your kind, detailed introduction. The topic that I have to deal with you today, role of an instructing attorney. So before I commence my topic, I like to give a brief introduction. Who is an instructing attorney? When you pass out as a lawyer and when you complete your practical training after 6 months successfully, you will be enrolled as an attorney at law of the Supreme Court of the Democratic Socialist Republic of Sri Lanka. Supreme Court will never enroll you as a registered attorney or an instructing attorney. Having you passed out as a lawyer, when you make, if you have completed in law college and got through your conveyancing paper, you will be entitled to make an application to the Ministry of Justice to get your notarial license to practice as a notary. Acting in terms of section 4A, the Ministry of Justice will grant either license or warrant to practice as a notary. In the license, it will be set out what judicial zone or what district you can practice as a notary public. In addition to that, the Ministry of Justice will also specify what language, whether it is English, Sinhala or Tamil, what language that you can practice as a notary. In addition to that, once you pass out as a lawyer, you can also make an application to the Registrar of Companies to obtain your license to practice as a company secretary. In addition to that, you also could make an application to the Ministry of Justice to enroll yourself as a Commissioner of Oaths and to get the designation as a Commissioner of Oaths. Now you, by virtue of the fact becoming a lawyer, you will be entitled to practice as a notary, as a company secretary, as well as to get the designation as a Commissioner of Oaths. Now the question will arise, who is a registered attorney or who is an instructing attorney? Now another question will arise, whether like conveyancing paper, whether you have to sit for a separate exam to become an instructing attorney or a registered attorney, or what is the difference between a registered attorney and an instructing attorney. Now I will deal with that part of it. As you all know, Sri Lanka was a British colony during the period of 1796 up to the year 1948. When we were under the British rule, we have inherited many things from the Englishmen. Some of them are the legal profession and the legal system. Even now in England, the legal profession consists of two branches called solicitor and the barrister. Solicitor is the person who gets the first opportunity to meet the client, ascertain the problem and retain the barrister to argue the case. Barrister has no right whatsoever to have any direct link or communication with the client. In short, the solicitor acts as an intermediator between the client and the barrister. In Sri Lanka too, up to the year 1974, our legal profession had two branches called proctor, advocate. Proctor played a similar role as a solicitor and the advocate played similar role as the barrister. When this system prevailed, we had two different exams. to become a proctor, you have to get through your ordinary exam as well as English credit part in the same exam. Similarly, to become an advocate, you have to get through your advanced level exam and also English credit pass in the same exam. In the year 1974, then Minister of Justice, Felix Das Bandaranaike, amalgamated both professions into one profession called attorneys at law. In short, from the year 1974, everyone who is passing out Sri Lanka Law College called known as attorneys at law. In short, there are no proctors, no advocate, no counsel, no instructing attorney. Everyone is an attorneys at law. Although these both professions were amalgamated 46 years ago, some of them who are passing out from Sri Lanka Law College calling themselves counsel or advocate, they only argue cases. Similarly, some of the lawyers who are calling themselves either proctors, instructing attorneys or registered attorneys, they do only the deed work, filing proxy, running officer. So that is the background or the historical background of the word called instructing attorney. So let's get back to the today's topic. Today's topic is role of an instructing attorney. In that, I'll have number of items to discuss. I'll tell you the first thing is a initial consultation with the client. Now, when you pass out as a lawyer, client is coming to you and giving instruction to handle a case. Now, as you know, the profession is already crowded. Annually, well over 10,000 people, students are applying to enter Sri Lanka Law College. Out of 10,000 direct application selected people will be 250 from the Sri Lanka Law College. In addition to that, from various foreign universities, Sri Lankan universities, foreign institutions, Sri Lankan institutions, another 750 will be absorbed. Now, when annually about 1,000 lawyers are passing out, how do you accommodate them? And among the people, if you happen to be one, how will you shine yourself? How will you keep up? How will you impress the client? That is very important. To impress the client as well as to get into a position as a lawyer and also to have to create impression with the client, there are a couple of things you have to do. Mainly, first thing, you should know what is happening globally and you should know what is happening locally. And you should be familiarized with the local laws of the country and Supreme Court judgments time to time impose various rules and regulations, gazette notification and circulars. In short, you should know, you should be updated with the day-to-day events in the country, more particularly legal matters. Now let's get back to the first thing what I discussed with you, initial consultation with the client. Now client coming and giving instruction to you, for example, we'll say, because today the divorce cases rates are very high, quite a lot of cases are daily filed in the district court in various parts of the country. So let's talk about some divorce cases. So now say for example, a divorce client, a client is coming saying, sir or madam, I have a divorce case to handle. Now you have to be prepared. How do you prepare? So tell the client first of all, when client give instruction and say I have a matter, ask them to either by email or to drop a file and say what is the dispute, can you have a brief summary, can you have a brief summary. So when you get a brief summary, it could be fall into one of the three categories. A, it could be a matrimonial dispute, mainly it can be a divorce or it can be a custody issue, it can be a maintenance issue. So assume for a moment it's a in regard to a divorce, say parties are getting a divorce. The first of all you have to look at is jurisdiction, where to file the action. In the Civil Procedure Code, section 597, subparagraph 1 clearly states you can file action where the husband or the wife resides. In short, where the plaintiff or the defendant reside. What is happening today? Although the law says it, some of the counsel as well as some of the instructing attorneys tell the client, look, I don't go out of Colombo. Can you get a local address of a jurisdiction of this area where I am practicing and to file a case? Nothing wrong. You can file an action. What will be the result in position? If the defendant's lawyer take up the position, you are not living within the territory of the jurisdiction, in terms of section 597 subparagraph 1, your action will be dismissed. And then what happens? Action filed by you will be dismissed. Client also will dismiss you. Client will report you to the bar association. So never file action to suit an instructing attorney or suit a client. You have to abide by the law. That is in regard to the jurisdiction. Now having gone through the jurisdiction, the second matter that you have to look into, the second one is what is the cause of action. Where the cause of action is set out, then you have to look at and see section 19 subparagraph 2 what are the grounds for divorce? There are three grounds for divorce. First one, desertion. That has two categories. Either it should be malicious desertion per se, or it is a constructive malicious desertion. What is the difference between a malicious desertion and a constructive malicious desertion? In the malicious desertion, the party who leaves the matrimonial home will be guilty. In a constructive malicious desertion, the party who is making miserable to the other party is guilty. So that's the difference of malicious desertion in twofold. Either it should be constructive malicious desertion or malicious desertion per se. The second thing is an incurable impotency. That means the defect cannot be cured. Then the third one, adultery after the marriage. It is adultery after the marriage, not prior to the marriage. Having got through the marriage, you can't dig into the history of a man or woman and say, well, you had so many affairs, you lived in adultery, I am going to sue you. No, it is not permissible in law. So those are the things. So having looked into the jurisdiction, there will be other issues where the client come and as I told you, there are quite a lot of divorce cases are filed. Therefore, I'm actually in this lecture, what I am discussing the practical side. I'm not going to give any theory, because theory you learn in law college for the last 3 years, plus you did your apprenticeship. So I'm only going to deal with the practical problems that you are going to face with. I'm going to spend more time with divorce because you get more divorce action. So that's what I'm going to discuss about the divorce matter. A client come and tell you, look, sir, I lived in separation for a period of well over 7 years. If there is any possibility for me to get a divorce on the ground of 7 years separation. The 7 years separation has been set out in section 608, subparagraph 2 of the Civil Procedure Code. We call in Latin term, mensa et thoro, living in separation for a period of well over 7 years. So now the question is whether that is a ground for divorce. That is a matter discussed in Thinnakon versus Thinnakon case. I'll give you the reference. Okay, I'll give you that reference shortly. In that case, where the court held that in a 7-year separation case, in addition to 7 years, you have to prove a matrimonial fault. The reference is 1984 2 SLR 217. I'll repeat it again. Thinnakon versus Thinnakon, 1984 2 SLR 217. In this case, the facts of the case are a person, virtually the husband, living in adultery for a period of 7 years, filed a divorce action on the ground of 7 year separation. So Supreme Court held in a 7-year separation case, apart from the 7-year separation, you have to prove a matrimonial fault. Otherwise, you can't get a divorce. Then the question will arise, why this section was introduced? Because this is not a cause of action set out in section 19, subparagraph 2 in the General Marriages Ordinance. This section 608, subparagraph 2 was introduced to expedite the process of divorce. Now, normally in a divorce action, you file a regular divorce action, summons served, answer file, replication file, goes on pre-trial, then it's a protracted process. If you do file an action on the basis of 7 years separation, all what the court will do, this is a summary procedure, to expedite the process, they will issue nisi in terms of section 377 subparagraph A of the Civil Procedure Code, nisi to show cause why this nisi should not be made absolute. If the other side come and say, yes, I do agree, but the other side said that we were living in separation for well over 7 years, I am also agreeable for a divorce, that's the end of the matter. There won't be any protracted. So in short, section 608 subparagraph 2 is a matter of expediting the procedure. It is not a ground for divorce. So in short, in 608 subparagraph 2, what says, apart from the 7 year separation, it is mandatory that you have to have a matrimonial fault. Otherwise, you can't get a divorce. Similarly, there are very often people who are living in Sri Lanka, in various parts of the world, they have now migrated, they get married in the respective country. So when they get married, when there is a matrimonial dispute, they come back. Now, another client coming and asking you, sir, madam, I got married in India to a Tamil gentleman, marriage didn't work properly with my children, I have come back. Can I institute action in Sri Lanka, but the marriage took place in India? I'm sorry to say, when you consult even the very senior lawyers, they turn back and say, no, if you have got married outside the jurisdiction of this country, Sri Lankan court has no jurisdiction, which is factually incorrect. Although General Marriages Ordinance or any other laws have not given that as a cause of ground for divorce when it contracted outside the country, Sri Lankan court has jurisdiction based on a case called Asogan versus Asogan, that is 1984 1 SLR 413. In this case, a Sri Lankan lady married an Indian gentleman in India, was settled down in India, came back to Sri Lanka due to matrimonial dispute, filed action in Sri Lanka. When filed action, court dismissed the action on the basis Sri Lankan court has no jurisdiction. But the reason for the dismissal is, as at that time, the law prevailed was a very old case, 100 odd years old case called 1 SLR 160, Lamasuria versus Lamasuria. In that case, a British gentleman got married to a Sri Lankan lady in England. Then action was filed in Matra court to get a divorce. So the gentleman took up an objection and said, look, Sri Lankan court has no jurisdiction because I got married in England. Court upheld because at that time the law prevailed was General Marriage Ordinance, old one, not the new General Marriages Ordinance. In addition to that, the Civil Procedure Code section 597 subparagraph, what is in existence, was not there. What does section 597 subparagraph 1 say? You can file action where the husband or the wife resides. So based on that, Privy Council distinguished the judgment and said, look, if a marriage contracted outside the country, Sri Lankan court has jurisdiction to dissolve such marriages, notwithstanding the fact that the marriage took place outside the country. The only ingredient what has to be proved is one of the party, either the wife or the husband, the plaintiff or the defendant residing in Sri Lanka. That was Asogan versus Asogan. That's the case. I am the one who argued unsuccessfully in the district court, but I succeeded in the Court of Appeal. Court of Appeal held new case, that is back again, I will give you the reference, 1984 2 SLR, 1994 1 SLR 413. Now from these cases you could see merely knowing the laws, rules, regulation not suffice. You should know what is happening around. So the judgments given the Supreme Court, appeal courts are becoming the law of the land. So you should be familiarized with judgments, otherwise you can't practice. As I told you at the beginning, you can't shine yourself as a lawyer if you are not familiar with these judgments. So assume for a moment a client coming, consulting you. You are returning, telling the client, look, I'm sorry, no action can be filed because your marriage took place outside the country. Go to another lawyer. That lawyer will say, no, this lawyer knows nothing. The correct law is Asogan versus Asogan. These are judges. So you have to be updated. Otherwise, you can't succeed and maintain yourself as a good lawyer. As I told you, it's a very competitive profession, and to maintain, because there is a famous Latin term called ignorantia juris non. Not knowing the law is not an excuse. In Sinhala we say, nitya nodaskama nidhasab noe. It is not only applicable to the lawyer, it is applicable to the general public too. So you should know. You can't say, I don't know. If you don't know, you can't practice. So that's the third one. Now similarly, there could be occasion where a client will come and consult you and say, look, I was living in adultery. My husband filed action on the ground of adultery. I have 2 children. I did not contest the case because in fact I was living in adultery. My husband got the divorce in his favor. Nice I granted, absolute granted, children are handed over to him. Now after a couple of years, my husband is now remarried, having another child by the second marriage. Now he is ill-treating. Can I get my children back? Because he is ill-treating. But of course, I was the guilty party. I could not do anything at all. Now I left the second man. Now I am on my own. Can I get it? Back again to this source. When you go to lawyers, lawyers will turn back and say, look, divorce case is over. Nice I granted, absolute granted. You didn't fight for the custody, you can't get. That's not correct. The real law is section 622 of the Civil Procedure Code categorically states, even after the dissolution of marriage, court is the still upper guardian in regard to the minor children. So therefore, you can still make an application to court to say, I want my children back, my children are ill-treated. It's very clearly set out in section 622. The judgment on the point is, 46 NLR 464 Blanche Ainley BLANCHEANLEY versus Herbert Boyce 46 NLR 464. So these are the matters I gave it. This is in regard to the first issue called advising the client how to it's the initial consultation with the client. Now you had a consultation with the client. What is the next step? Advising the client and deciding how to proceed with the matter in dispute. Now you met the client, discussed the matter. Now you have to tell the client how to proceed. In this matter, there could be a couple of occasions could occur. For example, a client may come and consult you. That particular client, when he come and consult you, that particular matter in issue could be fall into twofold. There are certain instances, it can be criminal, it can be civil. Now to give a hypothetical example, a client coming and consulting and said, sir, I got a check and that I deposited the check got bounced. The remarks are, account closed. What can I do? Now a situation of that nature is falling into two categories. A, on the face of it, when you say account is closed, knowing very well no such account is in existence, you are issuing a check. That's absolutely a fraudulent thing. So on the face of it, it's a criminal action. So you can file action in terms of the debt recovery law to punish the person. Please understand and tell the client, magistrate courts are not recovery court. Those are action against, it's like torts, action against state. The man will be punished and he'll go to jail. That's all. And sometimes he can come and say, look, I issued a check for 10 million. I am bankrupt. I'll pay 500,000 a month. I think it will take during the lifetime of a person to pay the money. That's one. And the other thing is, come back to these kind of action. You have to look at the person's background who issued the check. If he is a habitual crook, if he is a person with no repute, no point of filing a action in the magistrate court, because he will go to his second house, because jail is his second house. But on the other hand, if he is a reputed person, if he is some company chairman who has certain reputation in there, then definitely he will be very worried, because when he is taken into custody, arrested, kept him in jail, he will not go. He will say, no, by hook or crook, I will pay this money. That's the first thing. The second thing what you can do is, you can file action in terms of the provisions of Civil Procedure Code, summary procedure, that you call Chapter 53, Section 703, summary procedure. So in regard to check, bill of lading, pro note, you can file summary procedure there. What do you mean by summary procedure? The difference between a summary procedure and a regular procedure. In a regular procedure, when an action is filed, when the summons is served, as a matter of right, you are entitled to file an answer. But in regard to a summary case, you can't file answer as a matter of right. As I told you, for example, a check case. In regard to a check case, when a liquid claim case is filed in terms of Chapter 53, summary procedure, summons will be served. Summons will categorically state, from the date of the service of the summons, within 14 days, you have to file papers for leave to appear and defend. If you don't file papers to leave to appear and defend as a matter of right, you are not entitled to file the answer. So what have you got to do? From the date the summons served, within a period of 14 days, you file papers for leave to appear and defend. So when you file a petition affidavit and asking for leave, there are a couple of things court can do. A, in the first instance, if the court is fully satisfied that you have got a valid defense, then the court will turn back and say, yes, I am quite satisfied with your defense. I allow you to file answer unconditionally. Then you can file the answer. The second thing, if the court is satisfied with your defense partially, court can say either deposit 50% or 75% if you need to file the answer. If the court is not satisfied at all, what will the court say? No, you can't file the answer without depositing the entire sum. Deposit the entire sum if you need to file the answer. So those are the three things happen. A, having received the summons, if you do fail to turn within 14 days and file papers, no question of ex parte. In terms of Section 704, subparagraph 1, judgment will be entered as prayed for in the plea. Similarly, when a courts make an order, either deposit full money or part money, when you fail to make the payment back again, judgment will be entered. That's the first example. Now take a second hypothetical example. A client coming and telling you, look sir, I possess about well over 100 years title deed for my great grandmother, grandfather, everyone. Suddenly, and also we are in possession for well over 25 to 30 years, suddenly some thugs came and evicted us from the premises. What are we to do to get the possession quickly? Back again, this falls into two categories. Either it could be criminal or could be civil. What even by criminal, it's a forcibly eject of the premises. It's a total thuggery, and also it's a criminal act. Then you can, two things you can. A, you can make a complaint to the police and get the police to institute Section 60's application in terms of the Primary Court Act to put you back into possession and to get an order in terms of Section 67, subparagraph 1 of the Primary Court Act. Assume for a moment, okay, take for example, you make the application, you make a complaint to the police is inactive. What you can do, you can file a private claim in terms of Section 66 as for a court order. Now, in a case of that nature, the magistrate will never look into your title report, deeds, and say who is in possession. It's immediately for the judge. Judge has to do only simple thing to maintain the breach of peace. The police, in terms of Section 66, the complaint that will make to the court is, look, there are X and Y are fighting. We don't know who is the real owner, there is a problem. They are trying to kill each other. So the magistrate will look in to see how to maintain the peace. So even assume for a moment you got ejected, you slept over your right without taking any steps for 60 days. He may be a thug, he may be a crook, he will get the possession. Why? If he can prove 60 days possession. So in this kind of cases, magistrate will never look into the ownership, see who is in possession for the last 60 days, and specifically make an order. This order is temporary until the proper adjudication made by a proper civil court. Then the next step, having got the order in your favor and you are put back in possession, you can get ejected again. So what have you got to do? You have to go to the district court, file action, and get a court order. Ask for, first of all, declaration title to declare that you are the owner. Having asked for a declaration title, the second thing what you have to do is you have to ask for a court order, enjoining order, restraining whoever that other party, their servants, agents, and everyone interfering with your possession. So those are the two things. Now we dealt with two issues. First matter I dealt with initial consultation with the client. Then the second thing is advising client deciding how to proceed with the matter in dispute. Now we have decided how to proceed with the matter in dispute. Now the next step is see jurisdiction. Okay, now you decided either to file a civil action in regard to check matter or in regard to a land matter, you decide to file a case. Now the question is jurisdiction. In regard to jurisdiction, I dealt with you section 597 subparagraph 1 in regard to the divorce. In regard to the divorce, it's crystal clear. It is to be filed either where the husband or the wife residing. Now the question arises in regard to the rest of the matter. The rest of the jurisdiction is set out in section 9 of the Civil Procedure Code. There are a couple of links. A, you can file action where the defendant resides, or where the contract sought to be enforced, or where the course of action arose, if it is a land action where the land is situated. The position is different when it comes to a question of testamentary cases. In regard to testamentary cases, you have to file action A, where the petitioner resides, or where the death took place, or where fully or part of the property situated. So in addition to that, in regard to section 9, it has been stated, time to time, the Ministry of Justice either enhance or reduce the judicial zone. If you could remember from recent past, in regard to Mount Lania, the Mount Lania part of the jurisdiction went to Nugegoda. So Mount Lania and Nugegoda, not always, at times act has a concurrent jurisdiction. Whatever action to be filed in Mount Lania, even if you file it in Nugegoda, it's okay, it has a running concurrent jurisdiction. Similarly, in regard to Colombo too, time to time, part of the jurisdiction rests with Colombo, or it will be there. Certain police areas will say, this police area going to such and such a location, it goes on there. So you have to be updated. Now say for example, then similarly, even part of the Colombo jurisdiction now gone to Kaduela. So action where you are supposed to file in Kaduela, if you do file it in Colombo, then the action will get dismissed. As I told you, what will happen, the resulting position, client will complain to you and said, look, this lawyer was unaware of jurisdiction, now action got dismissed, my cause of action is now prescribed, I can't do anything. I'm the overall chairman of the disciplinary committee. I receive so many complaints against the lawyers, mostly apart from the other problems that the lawyers are having, ignorant of the law. As I told you earlier also, the Latin term, ignorantia juris non. You can't, everybody presume to know the law. You said, I don't know the law. That is what I said, you have to be updated. So jurisdiction is a paramount thing you should know. You should be updated with time to time the Gazette notification. Now the next thing is in regard to the commercial transaction. In regard to the commercial transaction, the law prevails Act number 10 of 1996, Commercial High Court Act, where initially it was 5 million was the value. Now the 5 million has been increased to 20 million. Any commercial transaction, mainly which are falling within the ambit of Company Act 7 of 2007, winding up cases, all those cases you have to file action in the Commercial High Court. Even in regard to the Commercial High Court, there is a very recent Gazette notification. The parties who are living in Jaffna as well as Kandy, they could file action in those respective jurisdictions. Commercial High Court jurisdiction is given concurrently to Jaffna as well as to Kandy. So that is the number 2, the second item in the jurisdiction. Now the next step, when you are advising the client, you have to be cautious. On another matter is whether that particular action, the client is coming and giving instruction to file a case. Sometimes clients, knowing very well the actions are prescribed, slowly come and palm into us and say, madam or sir, can you file this action? Be cautious before you take over the brief whether the case is prescribed. If you have, just for the sake making a quick buck, if you do take a case and if the case happen to be prescribed, you will get into difficulty. Why? The client will say, well, it is a duty of the lawyer. He should have advised the action as being prescribed, never told me. Action was filed. I spent so much of money. Now the case got dismissed. Tell the client to pay the money, the lawyer to pay the money. So you have to be cautious. So in regard to prescription, I like to give you details in regard to each matter, how the prescription works. It's a prescription ordinance. Accident cases, the prescription period is 2 years. Accident cases are 2 years. If it is goods sold and delivered, it is within a period of 1 year. In regard to the land cases, 10 years, that is, if anybody could prove that the person concerned was in undisturbed, uninterrupted possession for well over 10 years, then it is prescribed. Then the fourth one is Section 66 application, that is within a period from the date of the ouster or from the date of got ejected within a period of 2 months. Defamation cases, it is 2 years. In regard to written contract, it is 6 years. Oral contract, 3 years. Mortgage bond, 10 years. Now come back to mortgage bond. From the date of the execution of the mortgage bond, within a period of 10 years, it is prescribed. But in between, if there is any part payment made, then you can count the period from the date that the part payment is made. Then in regard to check, pro note or bills of exchange or bill of lading, that is within a period of 6 years. Within a period of 6 years. Now come back to this checks, you have to be very cautious. There are 2 things. If a client issues a check and if you have not deposited the check within a period of 6 months, that is a stale check. Understand the difference. Validity of a bounce check to file action, 6 years. But if you have got a check and time period for you to prescribe same, to present same to the bank is 6 months, not 6 years. Then similarly, in regard to a testamentary case, initially it was 20 years, now it has been reduced by Act number 2011 of CPC. It is for 5 years, section 545 of the Civil Procedure Code. Arrears of rent, it is 3 years. Labor cases, it is 6 months. Possessory action, 1 year. As this is very crucial, quickly I'll repeat the prescription ordinance, those details. Number 1, accident cases, it is within a period of 2 years. Goods sold and delivered, it's within a period of 1 year. In regard to the prescription, that is land action, 10 years. Section 66 action under Primary Court Act, 2 months. Defamation cases, 2 years. Written contract, 6 years. And oral contract, 3 years. Mortgage bond cases, 10 years, unless otherwise a part payment has been made in it. Check, pro note, bill of lading, 6 years, they are again to present a check within 6 months. If you don't present a check, it is only a piece of paper, you call a stale check. Then in regard to testamentary action, in terms of section 545 of the Civil Procedure Code, within a period of 5 years. Then in regard to the arrears of rent, 3 years, labor cases 6 months, possessory action 1 year. So when a client coming and giving instruction to you to file a case, before you accept the brief, see whether that particular action is prescribed. If the action is prescribed, don't file. You know very well you can't maintain the action, because on the face of it, it is prescribed. All but the other side has to do is come and take only one issue, is the action on the face of it prescribed. Action be dismissed. So these are the matters you have to take. Then the next step is, what you have to look into is, most of these contracts, now when you get a thing there, most of the contracts has a arbitration clause. So there are, whatever, even you buy a today push bike or a motorbike or car, anything, when there is a dispute, there is an arbitration clause. The arbitration clause will oust the jurisdiction. You can't file action. So there are very often, now say in regard to the condominium property, developers disputes, various things has arbitration clause. So before you accept the brief, you have to be very cautious to see whether there is an arbitration clause. The meaning of an arbitration clause is, in terms of the Arbitration Act, the provision, court has no jurisdiction to entertain a case. Why? It is outside jurisdiction. So if you do, as I told you earlier, I receive many complaints against a lawyer saying, I entrusted this particular case to the lawyer, he filed the action and he never advised me. On the first day itself, case got dismissed. Why? There is an arbitration clause. Lawyer never disclosed to me that there is an arbitration clause. You have to be very careful. If you don't advise the client that there is an arbitration clause and halfway through action get dismissed, you will have a problem with the client. Client will report you to the Supreme Court. So you have to be very careful when there is an arbitration clause. Now let's come back to the third point, advising counsel to retain. Now you see, having got the, now you had the initial consultation with the client, then advise the client deciding how to proceed, whether it's a criminal or civil. Now you have to tell the client, advising counsel retain. So you have to be very careful retaining. Always give the first option to the client and ask him whether he has any lawyer to retain. If he knows anyone, say okay, give to his choice. But don't retain the best criminal lawyer for the civil case. Similarly, best civil lawyer for the criminal case. But you have to be very cautious when you advise the client to retain a lawyer. You have to look at the client's capacity, because if you do advise a client to retain a president's counsel, if he can't make pay the fees, ultimately you will be liable. And similarly, you too have to be honest to the client. Now you are a newcomer, you are just passed out. If you do feel that it is difficult for you to handle, be honest to the client and tell him, look, I newly passed out, I prefer to have a senior with me and it will cost so much, and tell the client how much it is costing, and you have to do it. The next one, arranging a consultation with the counsel and meeting the counsel with the client. Now this is very crucial. Now say, assume for a moment, you got the brief and arrange it. So now today what is happening, when you are going to meet a counsel, most of these instructing attorney or a registered attorney, what they do, they prepare a very nice brief, go and give it to the counsel. When the counsel look into the file and ask, what is this matter? Sir, everything is in the brief. We know everything is in the brief. You are the instructing attorney. You must be able to open your mouth and tell what is the problem, what is the matter in issue, because this is the time for you to show your colors to the client. And if you can't open your mouth, and today most of these instructing attorneys, I call them photostat instructing attorneys. What do? When they do get a brief, they just beautifully photocopy, put it to a nice file cover, give it to the counsel. They don't know what is inside the file. Why? Their position is very simple. They think, look, we collect a very small fee. The massive fees are going to the counsel. Why should we worry about it? But understand one thing, the client is yours. You have a right to hire and fire the counsel. The client is yours. So if you are not up to the mark, if you go and give the brief to a counsel, if counsel feels that you can't open the mouth and talk, and you are just a dummy instructing attorney or a photostat instructing attorney, counsel will take over the client and tell, look, Mister, I don't think this lady or this gent is up to the mark. I have my own instructing attorney, can I have it? So the client will have no option, because the client also has seen your colors in front of the counsel. You lose your client. So for God's sake, when you are passing out as a newcomer, when you study, prepare a note, see what you feel, open your mouth and talk, because it's your client. If counsel is too smart, you remove the client. You can go to a counsel whom you prefer, whom you can have a control over. So don't allow the counsel to dominate the client. It's your client, as I'll repeatedly tell you, client is yours, you have a right, the client is yours, and the counsel is also under your control. So you have a right to hire and fire the counsel. So therefore you should be prepared and go through. Then the next one is this important: filing a proxy upon a commencement of a litigation. Now, proxy is a document where in a civil action, client authorize you to act for and on your behalf. So you have to be, all civil actions are commencing with a proxy. I call the proxy like a money spinner or like a taximeter. If you do your work properly, as long as your proxy remain in the case, you can mint money, provided if you do your work properly. Well, if you do fail to perform after getting the proxy and do your work, it comes like a death warrant. Your license will get cancelled due to the proxy. So when you file proxy, there are certain paramount things that you have to observe. The things what I have to observe is, number one, before you filing a proxy, A, you have to ascertain the identity of the person signing the proxy. So before you sign the proxy, you must be sure or certain who is signing the proxy. Number two, insert the national identity card number, passport. So before you sign get the signature of the client, you should be satisfy yourself by looking at the identity card, passport or driving license, whether he is the correct person. Third, ensure the person signing the proxy sign such proxy before you, because there are certain instances where seniors and even sometimes your good colleagues come and say, look, so and so is in a hurry, sign the proxy in front of me, can you file? Never to sign. Why? Lot of impersonation are taking place. Even your own senior say, I can't file this because this was not signed in front of me. Because there are divorce actions are filed in Sri Lanka where the parties are living abroad. When they come from abroad here, they find their respective husbands or wives have married somebody and even having children after that. But parties are there. So never to file proxy if it is not signed in front of you. Insert the date of signing the proxy. Now this is very crucial. When a client coming, giving instruction to you, filing a proxy, signing a proxy, the very same day you have to insert. Why I am saying the date is very important, I can give an example, one of my matter, where summons was served in regard to a divorce case. Say for example, today now we are on the 26th of October. Now you have a case where coming up somewhere and we'll say 26th of November. So he signed in the proxy today. After signing the proxy today, he is leaving the island. So when the case comes up, you put the date as 26th of November. But when you go to see that particular day, he was out of the country. So one of the divorce cases where I handled, similar thing happened, where a young lawyer filed the proxy on a particular day, hotly contested divorce case. I was appearing for the wife. Wife told me, sir, can you just check the proxy and say, when did my husband sign the proxy? So I gave a particular date. He said, no, my husband was never in the country. I don't think it is the signature of my husband. So I had no option. I took up the objection. Objection was upheld and the case was fixed for ex parte trial. After I got the case fixed for ex parte trial, I was a little concerned because a young, newly passed out lawyer who appeared, I went up to him and I asked, young man, why did you do a thing like this? He said, no sir, this is not a forged signature or anything. My client in fact signed on such and such a day. I forgot to put the date. I put the case date on that day he was out of the country. I felt very bad for this young junior, but I told this lady, look, I can definitely win this case on merits. This lawyer will going to get into difficulty because that lawyer has been threatened by the client saying that it's totally false of yours. I'm going to complain to the Supreme Court against. So with great difficulty, I managed to persuade my client. My client agreed to vacate the ex parte order due to the my conduct and giving an opportunity for the lawyer to vacate the ex parte order, finally the parties got together and now they are living happily. So you have to be very careful. Then the second thing is, in the case of a company or two there, so then in regard to the proxy, how a company can sign a proxy. Now, when a company is signing a proxy, you have to look at the memorandum and articles. Who is authorized or permitted to sign the proxy? So in certain limited liability companies are concerned, it says very clearly either two directors. For some limited liability companies, memorandum and articles will say one director and a secretary, or one director. So you have to be very careful, because if the proxy is not valid, it will be rejected by court. So if it's a company, if it's a sole proprietor, then you have to get the sole proprietor's seal and affix in the proxy. Similarly, if it's happened to be a partnership, then you have to put the two partners detail and get the company there. So if it's happened to be a party living out of the country, then you have to get the certified by a notary, solicitor, or High Commission, or Consular General, or Embassy. Similarly, if a person is in jail, then the document, that particular proxy has to be certified in front of the jailer or a superintendent of jail. So you have to be very cautious. Back again, I will repeat it. This is very, very crucial in regard to a instructing attorney's work. The instructing attorney work commences with the proxy. Number one, what have we got to do? Ascertain the identity of the person signing the proxy. How do you ascertain the signing of the proxy? Either you have to check the national identity card, driving license, or some form of identity. Otherwise, don't place your signature. Insert the national identity card number or the passport number, person signing the proxy. Then ensure the person signing the proxy signs such proxy before you. Insert the date of the signing of the proxy. In case of a company, it has to be two directors, or a director and a company secretary, and see how the company resolution, the article says. Then in case of a partnership, all partners must sign the proxy. If a party is living abroad, then his signature must be authenticated, signed by a notary public, solicitor, or relevant High Commission. Or if a party is in jail, then you have to get the thing. Now, have you got the proxy signed? Now, the most important thing is, when you file a case, how do you identify the person? Now, when you are there, when you file action, how do you do? Now, when you are filing an action against an individual, there is no issue. You file action against an individual, say Mr. X, you file action. Now, come back to the question of filing action against a sole proprietor. So, when you file an action against a sole proprietor, how do you do? You have to say Mr. X or Y carrying on business under the name and style of sole proprietorship such and such. You have to be careful. You can't file action under the trade name. You can't say there are various trade names are there. If you file action with a trade name, it is not a legal entity. Your action will be dismissed. Similarly, if you file action against a partnership, you have to be cautious. Partnership, you have to name X and Y carrying on business under the name and style of the partnership of such and such. If it is a limited liability company, then you have to say limited liability company. Now the next question arises, how do you file action against the numerous people out there? Say for example, against a political party, or against a club, against a society. There are numerous people. Now say for example, political party, you file action, there may be lakhs and lakhs or millions people are there to political party, in regard to a political. How do? You file action and ask permission, either the party chairman or the secretary, to be name him as a representative. That is what you call, in terms of section 16 of the Civil Procedure Code, to representative action. When there are numerous people are there, then to file action for and on behalf of them. In such situation, what the court used to do is allow the application and request the party, a particular party concerned, publish newspapers whom you are suing, either president or the secretary, whoever you are suing, and you have to publish. Addition to that, you have to put a notice in the particular headquarters or anywhere, and say such and such an action has been filed, naming you as a party for and on behalf of the particular respective political party or a club. Now let's get back to the other point. There, certification documents filed with the pleading. When you are filing action You have to, whether it's in the Court of Appeal, whether it's in the Supreme Court, whether it's in the District Court, you have to certify it as a true copy. I'm talking with experience, certain big law firms as well as certain well-known senior lawyers just certify documents as a true copy without even looking at the original. When you certify a document, what do you mean by a certification? True copy from the original. As I told you, I'm telling you with the responsibility. So many fundamental right cases have been filed in the Supreme Court. I can't imagine well-known firms, seniors are certifying as a true copy, but cabinet papers. How can you certify a cabinet paper as a true copy? Can it be in your possession? It will be in the cabinet. Now, similarly, certain sensitive information which will only be having at the intelligence. So you put as a true copy and sign. And similarly, internal memos of a company, secret document, you can't do that. So for all and sundry, when you say true copy, just put a true copy and sign. Never to do that. End of the day, what happens when you put such true copy, you will be ending in the 4th floor CID, because you have to say what made you to certify that as a true copy. The simple question CID will ask you, you have said this is true copy. True copy from what? It has to be from original. It can't be a true copy from another copy. So you have to be very careful when you certify any document as a true copy. You have to be very careful. Then there are various other things what a lawyer has to be there. Now next point I will be dealing with you is in regard, now when you are a instructing attorney or a registered attorney, there are certain paramount things that you have to do. Even if you do retain the best counsel in the country, as an instructing attorney, if you fail to do what you are supposed to do, the action will fail. Now, simple example is there is a new procedure called pre-trial procedure has been introduced. In pre-trial procedure, it is mandatory 15 days prior to the trial date, you have to tender the issues and admission. Similarly, 15 days prior to the trial date, in terms of section 121 of the Civil Procedure Code, you have to file list of witness and document. Now take for example, a hotly contested land case. You fail to file your list well in time. What happens? You can't summon a single witness. You can't produce single document. Your action will fail. So you have to be very careful. Make a note of it. You have to file your issues and admission as well as list of witness and document well in time. If you don't file papers well in time, your action will fail, and the resulting position is you will be struck off the roll. So there are series of actions, Recently also Supreme Court gave us 7 years suspended for a lawyer from Candy Bar. The problem there was, if I filed a fundamental right application, in the fundamental right application he has asked for a particular 3 days to support. Court gave a particular date to support. He failed to support that date. Thereafter he filed a motion for relisting. Again he failed to do that, and twice or thrice. So the Supreme Court ultimately had no option, 7 years suspended. So there are, as I told you over and over again, series of cases against a lawyer. People think when you are instructing attorney, no responsibility, nothing, you can make a quick buck, and it's not that. Because you have to understand far-reaching consequences you have to face. Now at the beginning of the lecture, I said it. Now when you pass out as a lawyer, there are a couple of things that you can do. Initially I said, look, you can practice as a lawyer, addition to that notary. Now when you practice as a notary, although I am talking about a registered attorney also practice as a notary. Now when you practice as a notary, you are duty bound and obliged to adhere to the mandatory provisions of the notary's ordinance. Now section 31 subparagraph 1 to 36 of the notary's ordinance specifically spells out as a notary what and what the things that you should do, what are the things you should not do. So if you do what you are not supposed to do, or if you indulge in activities what you should do, then what happens? End of the day, you have to face far-reaching consequences. If any client complains against you in regard to a professional misconduct, after a full inquiry by the Supreme Court, in the first instance, your license may get suspended or license may get cancelled. In addition to that, most of the people don't think about it. In terms of section 39 subparagraph G of the notary's ordinance, not only license get cancelled or suspended, not more than 5 years rigorous or simple imprisonment. Most of the law notaries thinks, look, once you get the notarial license, it's a money pinner. I can buy a printed form from a booklet, put the Dobie mark, get a court clerk or a notary clerk and make. Be very careful. That's one. Then I said that you can even do your work as a company secretary. When you work as a company secretary, back again, most of the people think, no, it's easy. I can buy some printed forms from the get it from the registrar of company, fill the forms, directors, shareholders, and make. No, there is a specific provision in regard to company secretary, Company Act. You have to send your annual returns and also necessary forms time to time. Failing with prosecution in the magistrate court. Then coming back even to practicing, getting the designation as a commissioner is a noble, not to make money. So you have to understand, registered attorney or instructing attorney is a very, very serious role. It's not a simple thing. And I'm sure, back again, I'm repeating about the notary's ordinance right. After when you get through the convincing paper, I don't think any one of you, including me, there's nothing for me to lie. Even I have not gone through the notary's ordinance until I was appointed as chairman of the professional purpose. Now I am going through daily. And having said so, when I receive the complaint, you must see those clients are quoting to me, having given the narrated the offence what has been committed by the notary. I kindly request you to act in terms of such and such a clause to take step. Laymen are more familiar than us. So it's a very, very noble profession, and you have to live up to the expectation. And I repeatedly say, when you pass out as a lawyer, people will look upon you a person with a caliber, a person with a quality, and a person with a stand. So you have to live up to the expectation. To live up to the expectation, I repeat it again, you should know what is happening around you. Update. Because even when you talk to a man in the society, he look upon you. You're a lawyer. So, you live upon. So I think this lecture you would have gained some experience. If that is so, I'll be very happy. So all the budding lawyers, I wish you good luck and God's blessing for your career. And thank you very much for your kind patience.
Thank you so much, sir. Would you have a minute to take a question?
Sure.
Right, we have a question from an apprentice who asks about, in a situation where you cannot find the respondent in a divorce, can an ex parte decision be given? If so, what is the status of the decree nisi, as it cannot be delivered to the respondent? What if he tries to reopen the case under relevant provisions?
The paramount thing or the basic thing, Shahan, is you can't get an ex parte order in terms of the provisions of the Civil Procedure Code. To get an ex parte order, you have to satisfy court summons has been duly served. Now, even in regard to a person who is living outside the country, you have to serve summons personally. Now, if you can't serve summons personally in terms of the provision of Civil Procedure Code, there is a provision where you can serve summons through the DHL courier service and get an affidavit from the respective service provider that it has been duly served. Even if it has been duly served, if that person doesn't turn up, the procedure hitherto adopted is to serve same through the High Commission. So no court will allow any ex parte until otherwise it is served properly. If it is not served properly and the nisi entered or absolute entered, it is a nullity. So you can easily file papers to set aside, and more particularly, if anybody can prove that the alleged, whatever the order given on that day, he or she supposed to be out of the country, all what you have to do is to provide, give the relevant documentation to show that the person is out of the country. It will be set aside.
Thank you very much, sir.
Yeah,
So I think our apprentices will benefit immensely from all the good advice that you gave them today. Now, students, you must remember that all this advice is given to you from 40 years of practicing law, after appearing in numerous cases, and each case is like a thesis. It's like a study in itself. And having been in so many high-profile cases, it would be good for you to follow this advice. So thank you so much for a beautifully presented session. We wish you all the best, in the years to come. You have completed 40 and we wish you the best for 40 more, sir. So thank you very much, sir, for being with us.
Thank you, Sharon.
Ladies and gentlemen, your next session is at 3 o'clock with Mr. Salia Piris, President's Council. I will see you then. Thank you.
Thank you, Sharon.